Ladies and gentlemen, the morning section of the Mediation Conference 2020 will commence soon. A reminder to all audience that this section will be conducted in English and Putonghua with simultaneous interpretation to English, Cantonese, and Putonghua. Please select your preferred language by clicking the relevant links on the Legal Week website to join the webinar. During the webinar, you're welcome to submit your question for our panelists via the message box, which is shown in the icon of a paper glider located at the right bottom corner of the screen. As a requirement for CPD application, please be reminded to fill in the evaluation form at the end of the panel and update your CPD training records accordingly. For better experience, you are recommended to use your earphones for the conference. Ladies and gentlemen, good morning. Welcome to the Mediate First More Than You Can Imagine Mediation Conference 2020. My name is Vinci, your host for today. Since 2012, Department of Justice has been organizing a range of large-scale events such as international conferences and public seminars to increase public's awareness on mediation. Mediation allows disputants to resolve disputes in constructive ways. This year, Department of Justice is proud to announce the launch of the new Mediate First logo as part of our ongoing initiative in promoting the concept of Mediate First. The idea of using Mediate First to resolve disputes before resorting to other means of disputes resolution. Now, let's take a look at our new Mediate First logo. What a beautiful and professional logo. It reminds us of all the great benefits of mediation whenever we see it. So remember, mediate first. Mediation Conference 2020, it's a one-day conference, consists of first panel discussion in the morning with second and third panel discussions in the afternoon. Our prominent speakers for today's conference come from various sectors and different parts of the world. They are here to share with us the latest updates on mediation. To start off with, we are honored to have Ms. Anna Shubhan-Brad, Secretary of the United Nations Commission on International Trade Law, to deliver a keynote speech for us. Ms. Anna Shubhan-Brad is the Secretary of UNCITRAL and also the Director of the International Trade Law Division in the Office of Legal Affairs of the United Nations. She is the 9th Secretary of the Commission since it was established by the General Assembly in 1966. Prior to her appointment on 24 November 2017, she practiced law in Paris, specializing in international investment law and investment dispute resolution. And prior to 2011, she was the senior legal advisor for the United Nations Conference on Trade and Development for 15 years. May I now invite Ms. Anna Shubhan-Brad for the keynote speech, please.
Good morning and greetings from Vienna. The Honorable Madam Secretary for Justice, Ms. Teresa Cheng, distinguished speakers, moderators, and guests, ladies and gentlemen. On behalf of the United Nations Commission on International Trade Law, UNCITRAL, I would like to extend my warm welcome to all the distinguished guests of the Mediation Conference 2020, organized by the Department of Justice of the Hong Kong Special Administrative Region, hosted for the first time in a virtual setting in light of today's unprecedented circumstances. It is with great pleasure and honor that I'm able to discuss the status of mediation and its importance in the current legal landscape. I'm pleased to highlight that this conference takes place at a particularly timely moment as the United Nations Convention on International Settlement Agreements Resulting from Mediation, more simply known as the Singapore Convention on Mediation, entered into force on the 12th of September 2020. The Singapore Convention on Mediation provides an effective mechanism for the enforcement of international settlement agreements resulting from mediation, and by doing so, the Convention contributes to the facilitation of international trade and the promotion of mediation as a credible, alternative, and an effective method of resolving commercial disputes. This novel convention opened for signature in Singapore on 7th of August of last year, and on the opening day alone, 46 states signed the convention, making it one of the most successful conventions developed by UNCITRAL thus far, in terms of signatures obtained on the opening day. Since then, 53 states in total have signed the convention, and there are now 6 parties, with Ecuador as the last one, that have deposited its instrument of ratification on 9 September 2020. It's our hope and expectation that the Singapore Convention on Mediation will rise to the position and the importance that the New York Convention has achieved for arbitration. We stand today with this great conviction that it's by no means an unrealistic hope. The Singapore Convention on Mediation closes the gap of the loop of the existing mediation landscape by providing an effective enforcement mechanism to international settlement agreements resulting from mediation, to build certainty and trust in the international mediation process. We are therefore hopeful that mediation will continue to be a useful tool that makes international dispute settlement more cost-efficient and effective. While the success achieved by the Singapore Convention on Mediation is truly extraordinary, it's equally worth noting that our work here is by far not finished. For the Convention to reach its full potential and effect, we must continue our efforts and invite more states and regional economic integration organizations to participate actively in adopting, ratifying, and acceding to the Convention. With this respect, we deeply appreciate the level of attention and interest that the Department of Justice of the Hong Kong Special Administrative Region has already given to the promotion and the development of its mediation system. It's our sincere hope that this level of interest in Hong Kong continues to increase and that more members of the international community will commit to the goal of strengthening the enforceability of settlement agreements resulting from mediation, which will further, in our view of course, strengthen the rule of law, the development of international trade, and the prosperity of world economy. We have come a long way for such innovative mechanisms that allow for enforcement of mediating settlement agreements to reach this stage, and we would like to invite even more participation and engagement to keep the momentum going. With the understanding that there is a need for unification of mediation regulation, UNCITRAL began its work in mediation as early as in the 1980s, and reached several milestones with the substantive contribution of states, intergovernmental and non-governmental organizations, and experts, as is always the case in UNCITRAL working groups. In 1980, UNCITRAL adopted the UNCITRAL Conciliation Rules 1980, which were the first international steps taken to harmonize rules for mediation. Over the years, however, it became apparent that contractual solutions alone do not meet the needs of the parties. So UNCITRAL adopted a model law on international commercial conciliation in 2002. The model law sought to strike a balance between the protection of the integrity and the flexibility of the mediation process. Then, in 2018, UNCITRAL developed 2 instruments in parallel in an effort to further promote mediation as an effective dispute resolution method: a convention providing the for the uniform and efficient framework for the enforcement of international settlement agreements resulting from mediation, and an update of the model law of 2002. Such a multilateral lawmaking process provides states with the flexibility to adopt either the convention or the model law as a standalone text, or both the convention and the model law as complementary instruments for a comprehensive legal framework on mediation. While the Singapore Convention on Mediation and the 2018 Model Law on International Commercial Mediation and International Settlement Agreements resulting from mediation, this is a long title, constitute significant milestones, there is still work to be done. Currently, UNCITRAL is in the process of updating the UNCITRAL conciliation rules and turn them into mediation rules to reflect current practice and ensure consistency with the Singapore Convention on Mediation and the Model Law of 2018. But also we are developing draft notes on mediation, which will provide the users with some guidance on the mediation procedure. Both the draft rules and the draft notes on mediation were on the agenda for this year's Commission session, but in consideration of concerns surrounding the hybrid nature of this year's session and its efficient use for legislative developments, they will be discussed and hopefully adopted next year, if, and we hope so, we can meet in person. In terms of the role of mediation in ISDS, several recommendations have been made by Working Group 3, the working group in UNCITRAL that is tasked or that is mandated to work on the reform of the investor-to-state dispute settlement system when considering this topic at its session last month. In an effort to continue work on mediation, the working group has provided guidance and identified preferences and way forward so that work can be undertaken to develop guidelines, rules, and model clauses to be used in investment treaties. In addition, we deeply appreciate the generous offer of the government of the Hong Kong Special Administrative Region to host an intersessional meeting to facilitate the sharing of information and mediation on mediation in the investor-state context and contribute further to the discussion of Working Group 3. While this meeting was postponed to 2021, we look forward to a pre-intersessional meeting on the 9th of November, which will provide a forum to contemplate a range of important topics such as overcoming challenges to the use of ISDS, a multi-tiered dispute resolution process, hybrid models of arbitration and mediation, and the way forward on mediation as a reform option for the ISDS framework. We very much welcome this timely event that is in line with UNCITRAL's mission and work, including the promotion of the Singapore Convention on Mediation, as well as mediation and ISDS. Now, with the current circumstances brought by the ongoing COVID-19 pandemic, collaboration and agreement proves to be more critical than ever. The mediated settlements of commercial disputes, which establish agreement as a core basis for facilitating ongoing and long-lasting commercial relationships, possess significant advantages and potential to support sustainable recovery in today's challenging circumstances. The United Nations General Assembly has recognized that the use of mediation results in significant benefits, such as reducing the instances where a dispute leads to the termination of a commercial relationship, facilitating the administration of international transactions by commercial parties, and producing savings in the administration of justice by states. Promoting the use of mediation in international trade and investment therefore facilitates solving conflicts without going through more formal and sometimes lengthy and costly adjudication processes. Furthermore, compared to arbitration, mediation can be carried out in a more flexible way and in a cost and time efficient manner that would permit to mitigate undue risks and enhance access to justice. For example, flexibility is preserved for states and parties, even in the Singapore Convention on Mediation. First, the Convention focuses on the enforcement of the settlement agreement instead of the rules for the mediation process. Second, the Convention only contains limited form requirements for settlement agreements to facilitate their expedited enforcement. And third, the Convention respects different methods for achieving expedited enforcement of settlement agreements, and it allows contracting states to enforce settlement agreements in accordance with their own procedural rules. The relevance of mediation, especially in the pandemic era, was also emphasized in our virtual panel series, Ancestral Texts and COVID-19 Response and Recovery, held in conjunction with this year's Commission session. On the final day of the series, the panelists explore how Ancitral's tools can help promote pro-women and gender-responsive policies in a post-COVID-19 environment, and specifically the role of mediation in encouraging a constructive and managed dialogue in a safe environment could be especially beneficial to women entrepreneurs. The importance of mediation, including online mediation, as well as the importance of the Singapore Convention on Mediation, cannot be sufficiently underscored in the uncertainties surrounding the pandemic, and there is much value in the level of flexibility and efficiency that mediation provides. Now, with the rise of online dispute resolution as an emerging worldwide trend, Ancitral is also ready to tackle today's ever-changing and quickly evolving legal landscape. With the draft rules on mediation as an update to the 1980 conciliation rules, although it does not explicitly contain the mentioned virtual or online dispute resolution, the draft notes on mediation mention online mediation. And another tool worth mentioning are the Ancitral technical notes on online dispute resolution, which was finalized and adopted in 2016, and as its title suggests, is particularly dedicated to online dispute resolution. Ultimately, such syntactical technicalities could be overcome by flexibility of the Ancitral texts. We're pleased that there is a panel dedicated to online dispute resolution today, and it is our belief that Ancitral's instruments translate well over the topic and can adapt to an online setting. Our texts are sufficiently generic and flexible to accommodate and address these types of disputes, and as previously mentioned, there is an ongoing effort to work on the specific language of the draft rules and the draft notes on mediation. Now, with special thanks to the Department of Justice of the Hong Kong Special Administrative Region for their tireless support to make this event possible, I would like to now invite everyone to engage in the three-panel session under the theme Mediate First, More Than You Can Imagine. I have full confidence that all participants will find the session informative, thought-provoking, and I wish all panelists and guests a fruitful and meaningful conference. Thank you very much for your kind attention and best of wishes.
Thank you, Ms. Anna Chabon-Brad. The theme for the upcoming panel section is United Nations Mediation Convention, Challenges for Mediators. Came into force in September 2020, the United Nations Mediation Convention establishes a harmonized legal framework for the right to revoke mediated settlements and their enforcement. This panel section will discuss the application of the convention and challenges faced by mediators in light of its constraints and exceptions on applicability of the convention. We are honored to have Professor TKU MH, consultant of Kwok Ng and Chan, to be the moderator of this section. Professor TKU MH is a Hong Kong leading mediation practitioner. He is currently a member of the Secretary for Justice Steering Committee on Mediation and the chairman of the Special Committee on Evaluative Mediation, Who's Who Legal 2020 says that Professor Yu is praised as a key player in mediation space, performing strongly in top-tier international mediations. It is our great pleasure and honor to have the following speakers in this section. Judge Deng Yu, Director of the Judicial Reform Office, Supreme People's Court of the People's Republic of China. Madam Guo Min, Team Leader for Diversified Dispute Resolution of the Case Filing Tribunal and Senior Judge Assistant, Supreme People's Court of the People's Republic of China. Ms. Winnie Tam, SBS SCJP, Barrister, International Arbitrator and Mediator of Default Chambers. Professor Nadia Alexander, Professor of Law Practice of Singapore Management University and Director of Singapore International Dispute Resolution Academy. Mr. Bill Marsh, International Mediator of Independent Mediators of UK. And Dr. James Ding, Commissioner, Inclusive Dispute Avoidance and Resolution Office of Department of Justice of Hong Kong Special Administrative Region Government. Please be reminded that we have a Q&A section right after this panel discussion, and you're very welcome to submit your questions to our panelists via the message box, which is shown in the icon of a paper glider located at the right bottom corner of your screen. I'll now pass the time to our moderator, Professor T.K. Yu. Professor Yu, please.
Greetings from Hong Kong. Distinguished guests, ladies and gentlemen, friends from Hong Kong and overseas. It is my pleasure to be here today to moderate the first session of today's forum. Today, we will talk about the UN Convention. And I would like to introduce our first speaker, Professor Nadia Alexander. Nadia Alexander is a world-renowned mediation expert. But to us, she is also a friend of Hong Kong. We are indebted to her for her contribution to the promotion of mediation in Hong Kong, in particular during the years when she was here as a professor and an advisor to the government. Concerning the UN Convention on Mediation, Nadia is the walking authority. As an award-winning author, she has written extensively on various subjects relating to the convention, and one piece of her work was published in the Hong Kong Lawyer last year. I had the privilege of working with her closely on the Hong Kong Apology Ordinance, the first and only piece of legislation of this nature in Asia, from consultation to enactment. Throughout the years, Nadia has been contributing to the design and drafting of dispute resolution legislation in more than 10 jurisdictions. Nadia, I'm sure you're ready. We would love to hear from you on the Mediation Convention. Right. Professor Nadia Alexander will give us an overview, intent, and purposes of the convention. Your time, my good friend.
Thank you, TK. Thank you, TK. Wonderful colleague and good friend for that very generous introduction. Can I check that everybody can hear me?
Yes, we can hear you well.
Okay, fantastic. And my understanding is that my slides will appear and I can operate them. Yes, and here they are. Fantastic. Hi, everyone. It's a pleasure to be kicking off this panel and talking a little bit about the new, still new, Mediation Convention. So Anna, now let me just check that I can click on here and trying to move the slides. So I'm having trouble moving the slides. I'm not sure what I need to do. Thank you. I don't know if I did that or the technicians did that. Anyway, Anna has very kindly provided some of the background to the Mediation Convention, and so I will adjust my comments accordingly in the time that I have today. But I think it's useful, before I get into an overview of the provisions, I think it's useful, to note just geographically and regionally who has signed or which countries have signed and ratified the convention. And if you look, there's a great, at this slide, there's a great geographical spread, and also a lot of some of the biggest economies in the world, but also quite a lot of small states. And I think it's important to ask yourself, you know, why? You know, we know we have an unprecedented number of countries having signed this at the opening ceremony. Countries are still signing on, and countries are ratifying. And I think the answer is in large part because mediation makes a lot of business sense, and I'll get back to that later as well. And I'm going to have to ask, thank you for my slide to be moved. So we have the three, based on data from 2019, three of the world's largest economies that have signed on. And in Asia, which is where most of us, I think, participating are, three of Asia's largest economies have signed on, and 5 ASEAN countries. Next slide, thank you. And yeah, I think Anna has covered the 53 countries have signed, and to date, 6 countries have approved. And now I'm really going to talk about, well, what was the intention, the motivation behind this, and what are the main provisions of it? And I want to start with the question in the next slide, please, which is, why bother? Why did we bother with a convention? Why did we bother with a convention when people often say, well, anecdotally, mediation has a high compliance rate. So that means when people sign on to a mediation settlement, mostly they stick to it. Sometimes they don't, of course. Why do we want a mediation convention when there's an increasing use of hybrid or mixed mode processes where you can use mediation within, for example, an arbitration process and get a consent award? And I think the answer to this was very present in the minds of the drafters of this convention. And it really is that this is about, in a narrow and a very important sense, it's about direct enforcement of mediated outcomes, mediated settlement agreements internationally. But in a bigger, deeper sense, it's about the visibility, it's about the credibility, and it's about the legitimacy of mediation in cross-border settings as a standalone dispute resolution process in its own right. And I think given the number of sign-ons, given how we've seen arbitration move from its inception with the New York Convention 60 years ago, and seeing how that's developed, we're going to see the same thing happen with mediation, facilitating international trade and commerce by managing disputes, but we're going to see it a lot faster, right? Because of a whole lot of reasons, some of which I'll get to later. So moving on, move to the next slide, please. All right, I want to show you some figures. Thank you, yeah. So this is from a survey that we conducted at CIDRA, which shows, not surprisingly, we asked people who used international dispute resolution, what do you use and where does mediation fit in? And not surprisingly, most of the users, lawyers and commercial users, said we use arbitration mainly. But if you look at mediation, which seems to come in 4th place here, but if you add in mediation as a standalone and mediation within a hybrid dispute resolution process, which came in 3rd, it actually comes in 2nd place. So mediation is being used a lot more already than we think, but it's being used a lot in hybrid processes as well. Why is it being used in hybrid processes? I won't show you the slide for that, but what our research showed is that users say we use a hybrid rather than straight mediation because, or rather than straight arbitration, because preservation of the business relationship is important to us, and somebody, either the lawyer or one of the parties, is a little bit worried about compliance, right? Is a little bit nervous, and using a hybrid gives us more confidence, but actually it's often mediation that we're after. If you look at the slide here it's on my right-hand side, but the one with gold, it shows the gold are the corporate decision makers, and the purple bar is the lawyer users, right? So the client users, if you like, and the lawyer users. And if you look at that, you'll see that the difference between using arbitration and using mediation when it comes to the actual corporate decision makers is much smaller, right? So the I guess, the focus on arbitration and international dispute resolution, not surprisingly, is strongly embraced by lawyers because that's been their practice and a practice they've built up over the years. Next slide, please. And again. Sorry, I'm just not sure how to press this. Yes. And again, this, if you can just keep pressing down the slides because I don't have control of them. Thank you. The top three factors for choosing a dispute resolution mechanism were enforceability, impartiality, and cost, right? We saw very high satisfaction rates with mediation when it was used, and high satisfaction with cost, high satisfaction with impartial, principled mediators, and direct enforceability was the piece that was missing. Next slide. So what the convention seeks to do, right, in I guess in the sense of in terms of the international dispute resolution landscape, is create a landscape of appropriate dispute resolution, where we have the New York Convention for direct enforcement of foreign arbitral awards, arbitration outcomes, where we have, if you look straight to the bottom, the Hague Convention on Foreign Judgments, which is also very new for direct enforcement of foreign judgments, and for mediation, the Mediation Convention for direct enforcement of international mediated settlement agreements. Moving on. So how does it work? This is what we're all here for. So this is a snapshot summary. So Article 3, I think, is one of the key articles in it. And if I can ask you just to press, thank you. Just keep, yes, and again, thank you. Article 3 basically says that the convention can be used as a sword or a shield. And what does that mean? It means it can be used if you want to go and directly enforce a mediated settlement agreement, but it can that's a sword, but it can also be used as a shield, which means that if you have a mediated settlement agreement and the other party goes, for example, to arbitration or to litigation and tries to for example, litigate the issues that have already been settled in your mediated outcome, right? Then you can take your mediated settlement agreement under the convention and hold it up, and it will be subject, of course, to some appropriate exceptions. It will be a complete defense. It will be a shield, right? So it operates both as a sword and a shield, and effectively it offers recognition, although the word recognition is not used for reasons that were required by some legal systems, but functionally it offers recognition of mediated settlement agreements, international ones, and enforcement, recognition and enforcement. Moving on, what do you need to show that you've got a mediated settlement agreement that falls under the convention? And again, if I can ask you to keep clicking there, and again, thank you. So really two main pieces of evidence, and this is in Article 4. You need to have the documented or recorded mediated settlement agreement signed by both parties. That can also be in electronic form, and the convention specifically, expressly recognizes that mediated settlements can be recorded digitally, might be contained in emails, and that's also an implicit recognition of the growing practice of ODR. So you need that recorded mediated settlement agreement document, and you need some sort of proof that it's resulted from a mediation, that the settlement agreement has resulted from a mediation. That can come from a mediation institution, for example, giving a certificate attesting to this fact, or it could be in jurisdictions where this is the practice, that a mediator might sign on the settlement agreement itself, not to endorse its contents, but rather to say, yes, this settlement agreement was a result of the mediation I conducted. Next slide, please. All right, which mediated settlement agreements, MSAs, are covered and which aren't? And again, thank you. So they need to be international and they need to be commercial. And I won't go into the definitions of those, but what's important is that consumer, family, and I think there's another click there, inheritance are not, and employment matters, those are not covered by the convention, And there are good reasons for that. The shortest reason being that it's not within UNCITRAL's mandate, and also it's harder to get agreement on internationally. So it's about commercial disputes, which also potentially includes investor-state disputes, depending on their particular character. So there's a lot of scope, I think, for investor-state mediation under this convention. Moving on. Now, there are a bunch of exceptions in Article 5. And some commentators have jumped up and down and said, oh, look at all these exceptions. But actually, they're exceptions that exist in any country where mediation practice is developed. And so they are conventions which relate to the parties' capacity, relate to, for example, the mediated settlement being reached or based on some fraudulent conduct. That's the second point in relation to the mediated settlement agreement, or not being complete. In relation to the mediation procedure, so there's been some, for example, breach of mediator standards, and that's a very high bar to prove that the mediator hasn't complied with standards. So I think mediators are safe, yet quality is required. And of course, there may be public policy reasons as well. Moving on.
Nadia,
Yes.
we have, the time is up, but you may carry on for a minute or two, right?
Thank you. I will wrap up very quickly. All right.
Thank you.
But I've lost the slides. All right. All right. Just a quick one. In terms of existing law, the convention also says if you would prefer to use some existing mechanism to enforce your mediated settlement agreement rather than the convention, you can do that. Basically, the last thing I want to say, and I don't need the slides anymore, is that the convention is an opt-out convention, so that if countries sign on without any reservations, then parties who seek to enforce a mediated settlement agreement in a country which is signed on to the convention will automatically be bound by the terms of the convention, unless they've expressly opted out in their mediation settlement agreement. However, there is the possibility for countries to, when signing on or thereafter, countries to make, signatories to make reservations. One reservation, there's two reservations that can be made. One of them basically says that, well, you can make a reservation so the government, if the government's a party to a mediated settlement agreement, they're not bound by the convention. And the second reservation is effectively that a country can sign on and make the convention an opt-in convention. So the default procedure is it's an opt-out convention. You need to expressly opt out, but there is a reservation. And I think only one country has made that reservation to date, I think. But the majority, it looks like, are not, which I think is a good thing, because that will very much help mediation moving into the international mainstream. Thank you very much.
Thank you, Professor Nadia Alexander. And if there are other points that you would like to cover, you may share with us during the Q&A session. Right. Thank you. And now we proceed to invite our second speaker, Mr. Bill Marsh, to deliver his presentation to us. Mr. Bill Marsh is also a friend of Hong Kong. I still remember we were at one time fellow adjunct professors of a local university. Bill is a full-time international commercial mediator since 1981 and has mediated a huge range of disputes involving governments, national and international business, professional firms, etc., from over 50 countries. Twice ranked as Global Mediator of the Year by Who's Who Legal. Bill is also an advisor on mediation, conflict resolution to many governments and bodies such as the European Union Commission, the UN, and the World Bank. He represented the United Kingdom in the UN negotiations to produce the UNCITRAL model law on international commercial mediation. Bill will give us an analysis of the convention from an international commercial mediator's point of view. Bill, I know that the time is not with you in the sense that it's midnight in London, right? Thank you so much, and thank you for sharing with us. Your time, please, Bill.
TK, thank you very much indeed. Good morning to everybody. It's actually 2:15 in the morning here in London, so it's a particular joy to be joining you all. It's actually genuinely a real pleasure and an honor to be here. Wish I could be with you in person, and one day that will be possible again. So I want to talk about the convention, really looking at it through my lens, which is primarily as a practicing mediator. As TK kindly said, I mediate a lot in the international context, as I come across the question of enforcement a good deal in practice, both in the private commercial world and also in investor-state mediations. So let me make 3 points in the time allotted to me about the convention. One is a point about the impact of the convention. The second is to pick up one area of risk in relation to the convention, potentially. And the third is to look at a policy consideration, which I think all of us need to bear in mind going forward. So the first point, if I could have my first slide, thank you. The first point is simply to note and to welcome the impact of the convention as a promotional force for mediation. And I want to pay credit to UNCITRAL here for its leadership and work on this. When I began in this field, which was 1991, we could not have dreamed of this level of credibility and stature of international recognition in the field of mediation that the convention provides. I come across a lot of discussions at national policy levels in particular about the convention, and all these things are indicators of the way in which the convention has pushed mediation up the agenda, both in policy terms and policy considerations, and also in commercial terms, where the credibility lent by the mere presence of an international convention has been a significant boost to the mediation process. So I think the starting point is to say this is enormously welcome. It's something we couldn't have dreamed of 30 years ago when I started in this field. And whatever the usage levels of the convention in terms of parties seeking enforcement, the symbolic and the stature, if you like, that is lent to mediation through the symbolic value of the convention cannot be understated. So I give that a huge welcome, particularly from my point of view as a practicing mediator, where of course the credibility of the process is in the eyes of the parties is crucial. Let me turn then, if I can have the next slide, please, to one area of risk that I see, and my good friend Nadia in her excellent remarks, and thank you for those, Nadia, touched on this as well. It's too early to tell how much of a risk this will be, but let me set out the possibilities. My concern is the risk of abuse of Article 5, leading to heavily contested enforcement proceedings, which undermine the reputation of mediation as a low-risk, informal, user-friendly process. So Article 5 provides, and Professor Alexander touched on this, various ways, in quite proper ways, quite absolutely acceptable ways in which enforcement of a mediated settlement agreement can be challenged. One I want to pick up on is where there is a serious breach by the mediator of mediator standards. We have to bear in mind, of course, the context in which all this will be being looked at. So challenges to enforcement are necessarily going to be contested, otherwise there wouldn't be a challenge. So we're talking about a situation where one party to a mediated settlement agreement is seeking enforcement of it, and by definition, the other is resisting enforcement of In that context, I think it's fair to say that parties resisting enforcement will cast around for whatever grounds they can find to resist enforcement. And one of the obvious areas they may choose is criticism of the mediator under Article 5C. The kind of questions that raises, of course, we have yet to find out because these haven't happened yet. Let me just highlight some areas potentially of challenge. How can a mediator's conduct best be judged? If that's what the court, the enforcing, the court whose judgment is sought about whether a mediated settlement can be enforced. So what, for example, if a mediator is seeking to break an impasse between parties by adopting an approach to mediation which some mediators would find acceptable and others not? Are the commercial parties, presumably not trained in mediation, themselves able to make informed judgment calls about mediator conduct? Are judges able to make those calls? Since the disputes, and this is the heart of the concern, I think, since the disputes in question are by definition international, it's likely that parties will have different cultural norms and practices for mediation. So what if the mediator's conduct is regarded as completely acceptable in one context and completely unacceptable in another cultural context? And the question I'm thinking of here particularly might be reality testing. Some mediating cultures find a robust approach from a mediator completely acceptable. Others would potentially regard it as unacceptably aggressive. Whose evidence will be relied on? Will it be evidence concerning, will it be evidence given by the parties or by the mediator? And does that have an impact on the parties' confidence in confidentiality? And finally, will any of this have an impact on the mediator's performance and conduct? And I can tell you when I'm mediating in the domestic or international context, one feels entirely free on the whole to adopt whatever one thinks is the appropriate mediating approach. I don't know whether mediators might become more cautious, perhaps in an attempt to fend off any possible use by the parties, reference by the parties of your conduct as a basis to upset an agreement. So I don't mean to present a picture which is negative at all. None of this means that the convention won't work. What it does mean is there is a challenge there for all of us to reflect on about the way in which mediator conduct is judged in the international context, in the context of enforcement proceedings. One of the consequences of all that is that I think parties and mediators would be wise to not lose sight of the emphasis on self-enforcing mechanisms. Prior to the convention, that's largely all that parties had, and traditionally that's been of great use in mediation process. So the use of escrow agreements, the timing of payments, title not passing until full payment is made, security guarantees, etc. All that's been built into settlement agreements as a kind of self-enforcing process. And my plea, I guess, to parties and mediators and so on, it is not simply to lose sight of those self-enforcing mechanisms just because of the presence of an external enforcement mechanism like the convention. At its best, enforcement under the convention and self-enforcement mechanisms, I think, will operate very effectively hand in hand. Let me come briefly to my final point, which is a wider policy consideration. And the next slide, please, for this. Sorry, the next slide after that. Mediation and the law, to me, are like an old couple. And everybody knows, I've been married for 28 years, old couples understand that they both need each other, but they also need to give each other space in which to operate and thrive. And so it is with mediation and the law. They absolutely need each other, and this convention is a good example. Another example would be the legal framework relating to confidentiality. That might perhaps be a paradigm example of how much the processes, the mediation and the law need each other. They also need to give each other space. Mediation needs to operate as effectively as possible without the assistance or involvement of the law in order to retain its inherently flexible strengths and its freedom from becoming embroiled in legal challenge. And so I think it's important for us to recognize that the convention itself is an important shift in this balance. So what it seeks to do is enable parties to achieve by legally enforceable rights that which they previously had to achieve by consensus and commercial creativity. There's nothing wrong with that at all, but we need to recognize it's quite a big step and be conscious of its potential effects. It is, I think, part of a more fundamental question, which is to what extent mediation should be formalized and, as it were, increasingly part of the legal fold, the legal sphere. One sees this in many areas, not just in relation to enforcement, but also the training and accreditation of mediators, requirement to carry professional indemnity insurance, and so on. There is, I find, looking around the world, and I've worked with many governments on these issues, there is a widespread trend, I think, in favor of a greater connection between mediation and the law. I'm not against it. I would acknowledge that it's not where we began. So if I compare the informality of where we began to where we are now, we've now reached a point where the mere fact of entering into the mediation process, itself changes the parties' substantive rights and obligations under the law. So, for example, the mere fact of entering into a mediation entitles them to enforcement processes under the convention, and the mere fact of entering into a mediation entitles them in some jurisdictions to the suspension of limitation or prescription periods. So I'm not against this relationship at all, but I do bear in mind the old couple, mediation and the law. They do need each other, absolutely, and they also need space. And if I can finish on this note, our job is to make sure that we give both of them, mediation and the law, the right balance in their relationship so that the old couple, hopefully, will continue to thrive for many more years to come. Thank you very much.
Thank you very much, Bill. And we will have more discussion during the Q&A session. Right. Now, I would like to invite the third speaker of today's session, Ms. Winnie Tam, Senior Counsel. Winnie was appointed as a Senior Counsel in the year of 2006. Her practice areas include commercial dispute resolution and international arbitration, with particular expertise in intellectual property. Ms. Tam has been engaged as presiding arbitrator and co-arbitrator in a wide variety of commercial disputes. She is also a WIPO panel mediator, CEDA accredited mediator, a panel mediator on mainland Hong Kong investment disputes under SIPA, and as a mediator on many other panels. Winnie is formerly the chairman of the Hong Kong Bar Association. As a humble solicitor of the Hong Kong Bar Association, I can testify that Winnie has the most wonderful personality, and she is a great leader in the profession. Your time, Winnie.
Thank you very much, TK, for a very kind introduction. Today, I have the great displeasure in talking about the Singapore Convention, or what I will refer to as the Mediation Convention, from an international arbitrator's point of view. Now, I must profess that I am not a mediation expert, and then I have not even a fraction of the experience that Professor Yu and Professor Alexander and Bill Marsh have. And I would just look at it from the point of view of an arbitrator, from my understanding of mediation as an accredited mediator. Now, let's see if the... Oh, excellent. Now, how would the mediation convention impact on arbitrations? I think this is a question which many arbitrators would be interested in, because they will be able to envisage themselves being put in a position where parties desire the interruption of the arbitration process and to go into mediation. Then what will they do? Will they be able to fulfill the role and switch hats and then perform the role of the mediator? Now, Nadia has just talked about what makes arbitration the most preferred alternative means of commercial dispute resolution. She pointed out that it's foremost is the impartiality, enforceability, and the costs issues. And these would be in the parties, in the forefront of the party's mind. Now, for international enforceability, arbitration is not an issue because you have the New York Convention, which is widely accepted. Whereas for settlement agreements, that's another question, because I mean, settlement agreements at the moment, you can try to enforce it as a judgment or as an arbitral award. But if it is a mediated settlement before the Mediation Convention, it is not possible to enforce it internationally. But will the Mediation Convention be a success, given its a very prominent start? It came into force. It came into force on the 12th of September 2020, and then we see 53 countries signing up to it as of now, and 6 countries having ratified the convention. Now, as I see it, it is a very promising start, but whether it will be success, it remains to be seen. It will depend on widespread adoption in order to see its success. Oops. And a ready comparison is with the New York Convention, which is very widely adopted, 166 state parties, with 162 out of 193 of the UN member states. And another comparison to make is the UNCITRAL Model Law on International Commercial Conciliation, which is adopted by 33 states in 45 jurisdictions. So that is also considered to be, well, there is some promise to it, but we can't say that it has achieved great success. Now, so my view as an arbitrator is that the Mediation Convention is a very positive development indeed, with a lot of potential in the popularization of mediation. As the 2 previous speakers have pointed out, it has pushed mediation up the agenda and made international prominence. And that is a very positive development indeed. Now, 3 questions arise. Will there be adverse competition with arbitration? In my view, I don't think so, but I think there is going to be synergy between mediation and arbitration. I would foresee more parties considering mediation as an alternative to arbitration. But in time, they will learn that they can combine various modes of dispute resolution means and achieve the purpose desired. Will it be enemy of the third-party funders? Now, I do not know enough of third-party funding at the moment, because it is, in Hong Kong, it's still in its very, very early stage. And I can see that third-party funders would much rather there be a proper arbitration rather than a mediated settlement, in which case they may see themselves being excluded from the process. Because I do not, at the moment, it remains to be seen as to whether third-party funders will find this something which is against their interest. As regards, well, as I said earlier, as I can see it, mediation and arbitration will synergize with one another, and we will see, at the end of the day, a bigger pie for all. And it will be a very preferred means of dispute resolution particularly when combined with other means of dispute resolution in the event that mediation is not successful. The beauty of the combined adjudicative and non-adjudicative process can be seen in the following points. Now, we all know about these multi-tiered arbitration clauses. These arbitral mechanisms, sometimes is called ARB-MED-ARB or MED-ARB or ARB-MED. But at the moment, we can see also, difficulties, particularly in jurisdictions where there is no legislative infrastructure for the combined process. But although in places like Hong Kong, Canada, Malaysia, Singapore, Australia, and China, there has already been in place a legislative framework for these to be carried out. Now, in order to maximize the use of combined processes and achieve a synergy between mediation and arbitration, it is important also to have updating of institutional rules and provisions of model clauses. Now, in the following slides, I will provide some examples on the legislative framework and institutional rules. For example, in the ICC rules, there is no set modes or particular formulation of the combination of dispute resolution, but it gives enough liberty for the parties to choose to have these combined processes. Because under Article 19, it says where the rules are silent, it can be, the process can be carried out by any rules which the parties or the arbitral tribunal may settle on. And then Article 21 also provides that the arbitral tribunal, upon the agreement of the parties, can perform the role of an amiable compositor. Now, a more definite framework, a more well-defined framework under the arbitration ordinance provides the parties' consent in writing, then an arbitrator may act as a mediator. But the consent in writing is very, very important. And then it also provides that in the event that the arbitrator turns the procedure into a mediation procedure, it must first stay the arbitral proceedings before it proceeds to mediate. And then it also provides that an arbitrator who is acting as a mediator must treat the information contained by the, obtained by the arbitrator from a party as confidential, unless otherwise agreed by the parties or unless subsection 4 applies. I'll discuss confidentiality and subsection 4 of this provision in a later stage of this presentation. Now, under the HKIAC rules, the Hong Kong International Arbitration Center arbitration rules of 2018, there is, again, clear provision for a combined process where the parties agree to pursue other means of settling their dispute after the arbitration commences. HKIAC, the arbitral tribunal, or the emergency arbitrator may, at the request of any party, suspend the arbitration or emergency arbitrator procedure as applicable on such terms as it considers appropriate. The arbitration or emergency arbitrator procedure will resume at the request of any party to HKIAC, the arbitral tribunal, or emergency arbitrator. So it is a particular procedure whereby the process can only be changed into a mediation process or outside the arbitration by both parties agreeing to it. However, the arbitration can resume upon any party's initiation. Next, I would like to discuss the risks and challenges. Oops. The risks and challenges of the combined process. Well, one of the most discussed issues about the combined process is the arbitral tribunal switching hats. Now, under 33.5, Section 33.5 of the Arbitrations Ordinance, it says that no objection may be made against the conduct of the arbitral proceedings by an arbitrator solely on the ground that the arbitrator had acted previously as a mediator in accordance with this section. However, as I understand it, it is generally desired to be generally regarded as treacherous for the same arbitrator to then put on a different hat as a mediator because of difficult treatment as to confidential information, and sometimes doubts as to impartiality, as I've pointed out in the rest of this slide. Well, some lawyers have also pointed out that with the Singapore Convention, it may well be the case that parties will just opt for pure mediation and dispense with ARP-MED, ARP at all. Now, the risks and challenges of the combined procedure about confidentiality in MED-ARP. Under Section 33.4, as I have previously covered, but haven't sort of specifically referred to this particular provision, the arbitrator must, before resuming the arbitration proceedings, after switching it to mediation, disclose to all other parties as much of that information as the arbitrator considers as material to the arbitral proceedings. So parties choosing to use a combined process in order to take benefit from the Singapore Convention to get a sort of mediated award must be aware of the fact that if there were confidential information disclosed in the process of mediation, and it is this arbitrator conducting the mediation, then the arbitrator will have to disclose the confidential information to the parties so long as those information is material to the arbitral process. So to conclude, I consider the expression of the Chief Justice of Singapore in a speech given in 2016 apposite. He says that ADR should now stand for appropriate dispute resolution. So it is not alternative, but appropriate, with flexible use of different modes in combination and choosing the correct and appropriate process for the parties for the dispute. So, and looking forward, I would see that it will improve access to justice through flexible, diversified, and appropriate employment of different modes of dispute resolution. It will be a choice for the parties with knowledgeable professional advice, and we need to pay attention to capacity building and sharing of experience of otherwise confidential proceedings. Thank you very much.
Thank you very much, Winnie, and a very insightful presentation with conclusion of C.J. Menon's remarks, ADR being appropriate dispute resolution. Now, I would like to invite the fourth speaker for today. That is Judge Deng Yeo. He is going to present in Putonghua. Let me introduce him to us. Judge Deng has been working in the Supreme Court of the People's, Judge Deng has been working in the Supreme People's Court since the year of 2008, and he participated in judicial reform projects such as the reform of diversified dispute resolution mechanism, the reform of implementation system, the judicial responsibility system, and the drafting of judicial interpretation and policy documents. Judge Deng will talk about PRC's participation in global development of dispute resolution mechanism. Judge Deng, please.
Ladies and gentlemen, guests, friends, good morning to you. I'm very happy to have been invited by the Hong Kong Department of Justice to, in this COVID-19 epidemic situation, to join you online on this conference. And this is a new opportunity afforded us with the introduction of 5G. And it goes to show that this is a step forward in terms of providing one-stop international service. And this is exactly what we're talking about today. I very much appreciate this opportunity of sharing with you about participating in the global diversified conflict resolution mechanisms. In the country's Communist Party 18th plenary session, there had been a enhancement of the importance or raising of the importance of the improvement and perfection of diversified conflict resolution mechanism. And in 2019, Mr. Xi Jinping, the leader of the country, had also mentioned that non-litigation resolution mechanism should be in the forefront. And at the same time, this is going to be used, as pointed out, that there will be a raising of the standards and the enhancement of the efficacy of diversified conflict resolution and also litigation service for the people of the country, and at the same time to provide better service for the people, and also to bring on a new era of Chinese characteristics conflict resolution service model in order to promote justice, fairness, and also to serve the society and the economy in this new era of epidemic. And in particular, there had been efforts in raising the standards of the diversified conflict resolution. And also, this will be a social synergistic and also with participation of the public, supported by technology and led by the government and the party in terms of its system. That is, when we talk about ADR, the appropriate resolution conflict resolution, there are a number of areas for China. First of all, the policy will lead in terms of the development. There will be diversified conflict resolution methods, and the country will continue to modernize its governance to provide diversified means, and this will be in a systematic and foundational manner in terms of its provision. And all along, the diversified conflict resolution had been an important point in terms of development, and there had been some 30 policy documents and also judicial interpretations which have been promulgated by the relevant authorities of the government. And also there had been joint efforts from the various departments, including public security and the judiciary, etc., and the regulatory bodies, and altogether had been 28 relevant documents which have been promulgated. And there had been resources which will lead to the mediation with high quality and high efficacy as a method of conflict resolution. And also there had been a building up of 3D multi-level and refined mechanism for supporting the different conflict resolution mechanisms, and also building up of the internet-based judicial methods is also another area of development. And in particular, for the internet age, this is very much needed, the exploration of different ways of providing judgments, and also in the litigation system, how the internet and technology can be integrated in a deep way. These are all areas which had been provided impetus, resources, and had led to progress. The traditional systems will be modernized, and this will be providing high quality and high efficiency, synergistic and coordinated development of different ways of conflict resolution. And in this, there had been different systems, including there had been a commissioning of 40,000 special mediators. And also there had been mediating organizations set up in order to improve on the mediation system. And in this work, the Guangdong province People's Court had also promulgated the Guangdong Free Trade Zone cross-border commercial conflict resolution regulation. According to understanding, the Guangzhou city and also the Hengqin region and the Shenzhen area had also commissioned over 100 mediators and had handled over 1,800 cases, and the success rate had been very high. And the relevant commercial cases in terms of mediation, which had been given as a choice for the resolution of commercial cases, it had already reached 19% of all commercial cases. And at the same time, in 2019, in November, the Supreme People's Court, together with the Commission for Insurance and Banks, they had come up with a new promulgation concerning financial disputes resolution. So financial disputes resolution in terms of its process had also been given the diversified conflict resolution option, because the contracts and also damages arising from financial cases, there had been this new progress over with the mediation process and with the mediator's signature and with the confirmation of the efficacy of the People's Court. The mediation settlements have been well recognized, and the confirmation rate had been 94.5%. That is confirmation given by the People's Courts for the acceptance of the agreement of coming out of mediation process. That is a 2019 figure out of the 340,000 cases that were handled. And also there had been a streamlining of the process. In 2020, the Supreme People's Court had also, according to the NPC Standing Committee authority in Beijing, Shanghai, and 15 provinces and areas, had set up test points or pilot cases for the streamlining of the process for civil conflict resolution mechanism. And at the same time, there had been legislation, a legislating process on diversified conflict resolution. And this had been actively followed up in 7 provinces, including in Jilin province and others. So this is about diversified methods of conflict resolution. And at the same time, there had been publicity, exchange of views, and also perfecting the mediation mechanism and the codes for mediation for commercial cases, and also the link up of litigation with mediation and arbitration. All these have been raised to a new level. Again, I would like to thank you for inviting me for this sharing. Thank you very much, Mr. Deng.
Great momentum in the mainland. Now I would like to introduce the 5th speaker of today. Our 5th speaker is Madam Guo Ming. Ming has been working at the General Office and Case Filing Tribunal of the Supreme Court since 2014, with the focus on the implementation of the reform of diversified dispute resolution mechanism, synergy between litigation and mediation, and the implementation and promotion of the People's Court mediation platform. Madam Kwok will share with us the development of online dispute resolution platform of the People's Court in mainland China. And we are going to connect with Madam Kwok so that she could deliver her presentation with us.
Thank you. Can you hear me? Yes, we can hear you fine.
We can hear you.
Can you hear me? Greetings, everyone.
我们听到
Yes, we can hear you. I'm very delighted to have this opportunity to be able to speak at this Mediation Conference 2020. I will be talking about the development and also the building of non-litigation conflict resolution. Next page. In 2019, in order to follow the promulgation from the central government and also Mr. Xi Jinping concerning the diversified non-litigation conflict resolution, we have set up a one-stop diversified conflict resolution service. On the one hand, we have provided judicial protection for non-litigation conflict resolution methods, and at the same time, in the People's Court litigation service centers, we have set up mediation platforms and mediation rooms so as to bring on the different resources and the professionals so as to provide different platforms and different means of conflict resolution. Next page, and the next page, please. In 2013, the People's Court had already started with their smart court development. And in 2015, with ADR introduction, there had been an exploration of using video-based procedures. And then in 2016, there had been a opinion that had been published on modern information-based and technology-based diversified conflict resolution mechanism. And then in 2017, the pilot scheme had been set up. And in 2018, the People's Court platform had been brought on to implementation. This is the platform, and basically in the various functions, it is providing a remote participation in the conflict resolution process, and this already covers over 3,419 courts in the country, involving over 360,000 professional mediation organizations and involving 963,000 mediators, and also involving over 10.5 million mediation cases, and the success rate is a high of 61%. This is a platform which brings together and integrates the resources for mediation. And basically, it builds on the court's platform and also integrates it with the conflict resolution platform and bring those onto the court's platform so as to integrate the information, including the data and information, and also the resources. Basically, this had already been integrated or connected up with various service platforms, including the China Industry and Commercial Alliance, and also China Investors Net, and also China Finance and Consumer Conflict Resolution Net. These have all been connected up with the People's Court Conflict Resolution platform. The next page, please, and the next page. With this connection mechanism, there can be an entire process online procedure. For example, just to share one case, this is a Zhejiang province case, which is about false claims by a listed company. And basically, with the parties willing to come to mediation, the mediation case had been processed on the platform, and there had been a mediation on the platform, and that is on the China Investors Net. There had been the participation of the investors concerned, and in the end, there had been a successful resolution reached from the mediation, and it was a 2 billion payment in terms of the final settlement of the case. And according to the settlement, there had been a confirmation by the court of that mediation settlement. And during the epidemic period in particular, to allow the parties concerned to be staying in their own places instead of having to go to the court on site, that is a real advantage. The case that can be shared is about the person Tang Mo Yan and Tang Mo Mei, and this is about an inheritance case. One party was in Japan, and there was an impossibility of travel because of the COVID situation. And therefore, in the Anhui province, there had been an application made for a remote online mediation process to be conducted. And the mediator, through the online process, was able to reach a settlement between the parties. And the settlement had been pushed to the mobile phones of the two parties for signature. And after the signature, the settlement had been confirmed by the court. And that was a successful case. And further, let me talk about the road safety damage compensation. This is also on the platform. Basically, the insurance companies and the regulators, as well as the relevant parties, can go onto the platform to, first of all, get all the relevant information concerning the driver, concerning the road, traffic situation, etc. And there had been already 1,640 plus courts which are users of this road traffic synergistic platform. This is a figure as of the middle of October. And the success rate of the 370,000 cases is 78%, and the relevant awards of claims had been 11.1 billion RMB. So this is about the process, next page, of building a multi-approach to conflict resolution. And in particular, this provides a very good resource for mediation. And the mediation process is smooth, and it is highly efficient. And also it is on the leading edge because it is technology and internet-based. And the number of cases that it can resolve is also significant. So it is onto a very good trajectory. And further, in terms of China's characteristic conflict resolution multi-modal platform, the future development is for there to be more nurturing of professionals for mediation, and also increasing internet use and information-based processes, and also answering the demands of the people in increasing the efficacy of the platform, and at the same time increasing the confidentiality and also the relevant cases or sharing, and further to increase its internationalization. The courts will continue to promote this online mediation platform in order to resolve more conflicts. This is an international trend, and we are moving along in time. There are more conflicts which are now going for mediation. And internationally, this is increasingly more accepted. And in August, China had become a signatory of the Singapore Convention. And the courts have also set up their platform to incorporate the Singapore Convention. And also, we are including international experts to provide further enhancement in the platform so that the mediation can lower conflict, lower cost, lower the time needed, and also provide a platform or mode of conflict resolution that can be shared by all. The People's Court, even though there had been a slow start in this area of mediation, but we hope to, in the future, with the development of our platform, to provide a Chinese model for multimodal multiple options for conflict resolution.
ODR is so advanced in mainland China, right? I would like to learn more from you if I have the opportunity to visit mainland China after COVID-19. Right, now we would like to invite the last speaker of this morning's panel session. That is Dr. James Ding. Dr. James Ding is the Commissioner of the Inclusive and Dispute Avoidance and Resolution Office, EDA Office. We normally refer as EDA Office, and please follow the EDA Office social media platforms. Right. I love their short video clips and also the cartoons, right? James advises the government on various public and private international law issues, and he participates in international negotiations. James has published on different subjects of international law and international cooperation, and he has given various presentations at international and regional conferences, including the inaugural Global Conference 2019 HCCH Judgments Convention, the 32nd Law Asia Annual Conference, as well as various APEC workshops on online dispute resolution. James is currently the chair of the APEC Economic Committee. James will share with us his observations on the convention from the Hong Kong government's policy angle and the related issues. Thank you, James. Your time.
Thank you, TK, and thank you for speaking so highly about the social media of IDA office. I encourage you to take a look, and we will soon have the Media First logo also in our social media.
That's great.
Today, I'm going to share with you some of the views from the government, points of perspective on the mediation conventions and some related developments. Actually, there's not much I can say about the mediation conventions from the Hong Kong government's perspective, because we are still in the process of studying the conventions. But at this stage, I could share with you some of the preliminary observations about the conventions. Let me turn on the slide, yes. First, we note that this mediation conventions applies to mediations conducted anywhere in the world, not just within jurisdictions that have ratified the conventions. And the convention does not operate on the basis of reciprocity between the contracting states. The absence of this reciprocity can be explained by the lack of the state of origin of the concept of seats of mediations under the conventions. And we note that the consensus was reached in the working group discussions about this approach, since it's very particularly difficult to identify seats of mediations, and also there's a broad consensus to leave the mediated settlement agreement to the control at the state of enforcement rather than the state of origin, if one can ever determine where is the state of origin. In addition, we also looked at Article 8 of the Convention allows certain reservations to be made by contracting states. And in particular, we looked that it may exclude investment mediations involving investor-state disputes. The effectiveness of the conventions will very much depend on how frequent the contracting states are making use of these kind of exceptions or reservations, and that's something that we need to look further into it. These are just some of the preliminary issues that we are currently studying and the possible ramifications under the conventions. As mentioned earlier by the speakers from the mainland China, China signed the mediation conventions, and if the convention is to be applied to Hong Kong in accordance with the basic law, there are also some other issues, more local issues that we need to consider for its applications. The first issues relate to the local legislative framework on mediations. Currently, in Hong Kong, mediation is governed by the Mediation Ordinance, which provides for the legislative framework for mediation in Hong Kong. So we have to consider if the convention is to be applied to Hong Kong, whether there's any need to amend our existing legislative framework. In addition, we also need to consider the regulatory framework for mediators. For example, as mentioned by some previous speakers as well, serious breach of the standard or failure of disclosures by the mediators are the grounds for refusals to grant relief under Article 5 of the Mediation Conventions. And we are now looking into the current regulatory framework in Hong Kong concerning the standard of mediators and the mediation institutions, etc. These are also some of the issues that we are considering. And in addition, we also have to consider the treatment of mediated settlements not covered by the conventions. Because we are considering if we implement the conventions and there's a mechanism for implementation of the mediated settlements under the conventions, should we adopt the same mechanisms for those mediated settlements not covered by the conventions? For example, between Hong Kong and the mainland of China. So talking about the mediations between Hong Kong and the mainland of China, I'd like to share with you the SIPA investment agreement between Hong Kong and the mainland of China. Under the SIPA investment agreement, which concluded on the 28th of June 2017 between Hong Kong and the mainland, in the investment agreements, it provides for investment protections and other privilege and benefits for both sides. And in particular, I would like to share with you the mediations mechanisms under the SIPA investment agreement. Under the SIPA investment agreement, there's a detailed mediations mechanisms. Yes. The parties agree using mediation to settle disputes arising from an alleged breach of the substantive obligations of the SIPA investment agreements by one side, causing loss to the investor of the other side. The use of mediation has many advantages, and in the interest of time, I'm not going to repeat because I think almost all of the speakers have already covered the advantage of mediations. And in particular, the use of mediations in our view is also very useful and apt for the resolving investor-state or investor-government disputes. And under the SIPA investment agreements mechanisms, mediation mechanisms, both sides have each designated their own mediations institutions and mediators. And at the moment, there are a total of 4 mediation institutions. And we have also adopted mediation rules by the designated mediation institutions and mediator of Hong Kong. And the mediation rules were also announced on the 14th of December 2018. And I would encourage you to take a look at these mediation rules and our mediation mechanisms, which provide for a very comprehensive framework for settlement of investment disputes under the SIPA. And just to highlight a few key features of the mediation rules under the SIPA investment agreement, it provides a basic framework for the parties to make use of the rules to resolve their disputes, but there's also, at the same time, ample room for customizations by the parties. So the parties can also supplement and make necessary adaptations. And it emphasizes on cooperation between the parties and mediators in good faith. It also requires active participations to enhance the mediations expeditiously and efficiently. And we have adopted a default mediation commissions comprising of 3 mediators in such a way it gives greater control of the process by the parties. We have also set out a code of conduct for mediators to ensure their independence and impartialities. Since we have concluded the SIPA investment agreements, we have put strong emphasis on the need for capacity building and for training of mediators as well. As also mentioned by some previous speakers, capacity building is very important for the SIPA investment agreements mediation mechanism, and also I think for the mediation conventions as well for its success. So I think it's a very important element that we must not forget when we also talk about the mediation conventions. And in Hong Kong, we aim to provide international investment law and investment dispute resolution skills trainings with a view to building a team of investment mediators in Asia to handle international investment disputes. To this end, DOJ, my department, together with the International Center for Settlement of Investment Dispute and Asia Academy of International Law, we have organized 2 investment law and investor state mediator training courses in 2018 and also last year. It's the first course ever organized of this kind in Asia, with such reputable institutions joining hands together. And we have attracted over 100 participants from different jurisdictions, including legal and dispute resolution practitioners, academic and government officials. We're also planning to organize another training in 2021, and I very much encourage your participation in the training. And as mentioned by Secretary Unsechild, Ms. Jobin Brett, we are also organizing and working group 3 pre-intersessional meeting on Monday, next Monday, on the 9th of November, which will discuss mediations under the ISDS reform context. So we'll discuss the use of mediations to resolve investment disputes. So I also encourage you to participate, and I think that the registration is still open. Lastly, I will just mention some of the mediation initiatives and developments in the Greater Bay Area. The outline development plan for the Guangdong, Hong Kong, Macau Greater Bay Area supports Hong Kong to establish itself as a center for international legal and dispute resolution services in Asia and Pacific region. And we consider that this Greater Bay Area initiative, the GBA, provides great potentials for dispute resolution professionals in Hong Kong and also elsewhere, in particular mediators. In fact, GBA can be a good testing ground for the enforcement of cross-border commercial mediator settlement agreements. In Hong Kong, we have already adopted reciprocal arrangements for enforcement of arbitral awards and also for judgment in civil and commercial matters between mainland and Hong Kong, which are modeled on international instruments, the New York Conventions, the Hague Conventions. And so the Mediation Convention could also be a model for us to take into account if we are to develop a similar reciprocal mechanisms. And in fact, we have started discussions on the subject. We have established a GBA Legal Department Joint Conference since last year to facilitate communications among the legal departments in Guangdong, Hong Kong, and Macau. And the first joint conference was held last year in September in Hong Kong, and the 3 legal departments agreed to promote mediations in the Greater Bay Area to further work out the details, including formulating best practices, guiding principles relating to mediations and mediators in the Greater Bay Area, and exploring a mechanism for the reciprocal enforcement of mediator settlement agreements. So there are lots of developments on mediations in the Greater Bay Area, and in the process, we will also take into account developments at the international level, including the mediation conventions. The next meeting will be held in December, and will further our development of the mediations developments in the GBA. So that concludes my presentations. Thank you very much.
Thank you, Dr. Deng. And I had the opportunity to interview the SJ some time ago. And also from the speech and presentation of Dr. James Deng, we know very well that Hong Kong is going to promote mediation locally, in the mainland, and internationally. Now is the time for a panel discussion, and we welcome questions from you. Right. So let us have the panel discussion, and we will be joined by Professor Nadia Alexander, Mr. Bill Marsh, and also Judge Deng, as well as Madam Kwok. Right. Let us make sure that we are connected with them before we start this session. Right. I can see most of them here, and just want to make sure that Professor Nadia Alexander is also with us. Right.
I am here and my video is on.
Okay, lovely. So you are here, and we will start then. Right. I would like to start by this question to, oh, lovely, we can see your face, right. So the UNCITRAL Secretary has made a comment that the convention is closing the gap or loophole in the existing international mediation landscape. Right. I would like to have your views on that. Perhaps Nadia, perhaps, could you mind, you start first?
Very happy to. Thank you, TK. Yes, I think in terms of cross-border legal instruments, that's certainly the case. We have had for quite a while now the New York Convention for Arbitration. We have the Mediation Convention now, and we also have the Hague for mediated outcomes and the Hague Convention for foreign judgment. So in terms, if you think about mediation, arbitration, and litigation being, I guess, the three primary forms of dispute resolution and cross-border dispute resolution, we now have either in place or underway, in progress, legal instruments that facilitate the direct enforcement of those sorts of outcomes. So I think you've got a pretty comprehensive, the makings of a pretty comprehensive landscape, regulatory landscape for international dispute resolution.
Right, thank you, Nadia. And perhaps we can hear from Winnie. What is your view on this question? Right.
Thank you very much, TK. As a litigator and now an arbitrator, I think that mediation is indeed plugging the gap, so to speak. But in this respect, I think capacity building is very important because litigators and arbitrators, they are not normally involved in mediation. I mean, some are, but they're not normally involved in mediation. And this is a highly specialized skill, as I see it. So, yes, I very much welcome this plugging of gap.
Right, thank you. Right, I have got a question from the floor. Let me read this out, right. It is noted that the Mediation Convention does not contain the reciprocity reservation like the New York Convention. Will this feature provide more or less incentive for states to sign and ratify the convention? Bill, what do you think?
I'm not sure I'm the right person to come to on this question, but in a sense, the question exemplifies the whole challenge with this, which is that there are so many choices to make in relation to these processes, and choices need to be underpinned not only by capacity building, and I agree with the last point that was made, but also by starting with a reflection on policy. What are the fundamental policy considerations? What is one trying to achieve by all of this? So as a general principle, that would be my response to that.
Right. Any other speakers they would like to share? Dr. Deng, perhaps?
Yes, thank you, TK. As I just mentioned in my presentations, it's also one of the areas we are now studying because to some people it may have caused some free rider problems because those ratifying states will have to implement mediated settlements of all other states, including those not ratified the convention. So right. there could be an issue about free riders or possible abuse. But on the other hand, signing up to the mediation convention or ratifying it will be important signals to show the support for mediations and for promotion of mediations. So, so there are different considerations, and by the lack of reciprocity itself may not be the sole determining factors. Yeah.
I see. Any other views from anybody? Right.
This is Nadia. I'm not sure if you can hear me.
Yes, we can hear you. Carry on.
Okay, I think something's happening with my connection, but I am here. So I think it exemplifies, and this has been touched on, I think, by Bill, how different mediation is from arbitration and litigation, right? So there is no seat of mediation in the same way that there's a seat of arbitration. And that reflects in many things, but in part mediation practice. I mean, it's not uncommon I think, to have, at least in this part of the world, geographically progressive mediations, which means they might start in Hong Kong or Singapore, and then the next meeting's in Tokyo, and the next meeting might be online. And so it's not always possible or easy, let's say, to determine the state of origin of a mediated settlement agreement, which you require for a seat, right? And there's no supervising court. And so because of that, I mean, if you didn't have, and because of that, the principle of reciprocity just doesn't make sense. So what's important, you know, as James Ding has said, is the state of enforcement. And if you didn't have the convention, you'd still be looking at what's the applicable law of the contract, and parties still have control over that, right? The applicable law on the MSA. They can opt in or out of the convention at least. So they have some control over that. They can even put in a dispute resolution clause in there, and that's getting really complex, but we'll worry about that later. So, you know, so I think in one way, just focusing on the state of enforcement and whether or not the convention applies is just another way to talk about the applicable law when you come to enforcing a contract. So I don't think, you know, it will raise some unique questions, but I don't think it will be a disincentive.
Okay, right. Any other views from anybody? If not, then I'll move on. Another question from the floor. Professor Alexander mentioned that it is a high bar for mediators to breach the standard. How to determine the standards applicable to the mediators or mediation? So I would like to invite Nadia to perhaps to start first. Is it a high bar?
Look, it is a high bar, and I just want to start off by acknowledging Bill's point. Just because it's a high bar, because not only do you need to show that a mediator has, let's say, breached a standard, but you also have to show that that breach led to at least one of the parties signing on to the mediated settlement agreement. So it's, you know, difficult to prove at the best of times. But having said that, as Bill pointed out, parties will try it on when they're looking for a reason, or try it out rather, when they're looking for a reason to get out of their dispute. And so that's an area that we have to watch. Look, and I think it's a really good question. What's the applicable standard? And the quick answer is that courts in domestic settings have been figuring that out for decades, right? Particularly in countries where there's been a lot of mediation. And if I think about, you know, Australia is one example where there's been a lot of mediation, and where I come from, even before there was a national code for mediation, way back in 2003, there's a really well-known Australian case called Tupui and Leuenberg, where an action was brought against a mediator for being too coercive. And the courts then, even though there wasn't a national standard, had to figure out what were the standards of a mediator, what did the parties agree to. So just because it's not straightforward doesn't mean, just because it's difficult, doesn't mean that we can't figure it out. And that's often the sort of thing that courts will have to figure out as a last resort. And the last thing I'd say, which might raise more questions than answers, is that I personally don't think it's a great idea to have a universal standard, because if you have a universal code, chances are that you'll get a lot of lip service to that code, and it will be interpreted in very, very different ways by different cultures around the world.
Thank you. And what do you think, Bill? Any other?
Yeah, look, I mean, first of all, I fully agree with Nadia's comments. It is a high bar, and in fact, the phrase in the convention is a serious breach. So we're not just talking about a breach, it has to be a serious breach. And of course, as Nadia said, it has to be shown that it caused the loss and so on. I think the concern I have really arises out of the fact that mediation is always, as lots of things are, an expression of the culture in which it's practiced. And so when we're talking about international mediation, by definition, because that's what the convention applies to, one can see scope for very different understandings amongst the parties of what might be an acceptable thing for a mediator to do. And I have to face that challenge every week when I practice as a mediator in a international context, because parties have different expectations of not only of what the process will involve, but also of what mediators will do, of what kind of things are acceptable or not. I'm not, despite my comments in my presentation, I'm not overly worried about it. I think what will develop is a gradual sense around the world of the kind of things that are normal for mediators. But it's a work in progress, and so we'll have to wait and see.
Thank you, Bill. Good news for practitioners, right? So in the interest of time, we are coming to the end of today's session. Just like the theme of today's conference, Mediate First, more than you can imagine, this morning I have learned a lot from our distinguished speakers, Professor Nadia Alexander, Mr. Bill Marsh, Ms. Winnie Tam, Senior Counsel, Judge Deng, Madam Kwok, and Dr. James Deng. Right, so I would like to pass the time to our MC, and also this afternoon we have another interesting session. So stay tuned, go for your lunch, and then come back. Right.
Thank you. A round of applause to Professor TKU, Professor Nadia Alexander, Mr. Bill Marsh, Ms. Winnie Tam, Judge Deng Yu, Madam Guo Min, and also Dr. James Deng. Thank you so much for the insightful sharing and also discussion. Thank you so much. Ladies and gentlemen, here wraps up the morning section of the Mediation Conference 2020. Thank you so much for joining us this morning. As what Professor TKU stated, this afternoon section will commence at 3 p.m., where we feature the topics use of online dispute resolution in light of COVID-19 and also mediation advocacy. In a few seconds later, you will see a QR code shown on the screen. Do remember to scan this QR code to fill in the evaluation form for CPD application. Have a nice lunch and see you all again at 3 p.m. Thank you.